everyone doing today? So we're going to be covering the Bryan Kohberger hearing that happened yesterday. It's going to be a very short hearing in comparison to all the hearings that we've had before for Bryan Kohberger. Now, things that we're going to cover today. We're going to cover the hearing because the defense has asked for a motion for a continue. They want to delay the trial. They said that they have to get through the mitigation phase. I think that's incomplete at the moment. And then also there was it Dateline? I think it was Dateline. I forgot who the producers were. There was an episode about Bryan Kohberger, this case, this trial. And so they're like, hey, let's delay everything. Got a lot of discovery coming in and we need to process all that. So we're going to listen to the arguments today. Now, the judge has not made a decision yet. I think he's going to have a written order. But from what I've heard, it seems like the judge wants to have the trial to be on track, which is happening in August. And then additionally, there's nothing that popped up in my feed about a DoorDash driver possibly being an eyewitness for the state. I guess identifying Bryan Kohberger at the scene. So I haven't heard anything about this. I don't know if this is like also another leak or what is going on, or were people doing some sleuthing and then they were just like tying the two and two together or something like that. So I think we'll wait to get to the end of the hearing to get to that part. But for Bryan Kohberger's hearing today, again, they're going to have a motion to continue for about, I don't know, like 45 minutes or some shit like that. And then afterwards, they are going to have a sealed portion of the hearing. And that's the part where I'm more interested in, which is about the alternate perpetrators. But of course, it's sealed. We're not privy to it. So neither is the media, but it's okay. We'll have to wait until the trial happens for us to get all the information. But hi, Ginny. How are you doing today? Yeah, good luck during the laundry stuff. Hey, go lucky. Hello, hello. Taxi. All right, y'all. Let's just jump right into it.
Even Hitler presiding. Be seated.
I will say this, though. The audio should be way better for this one than it was for Donald Adelson. Yay. All right, we're going to listen in normal speed. Hi, Christine. How are you doing today? Hello, hello. I will say this, though. If they don't delay Bryan Kohberger's trial, I hope Donna gets delayed. I know that's me just being really fucking selfish, because I don't want to cover two trials at the same time. I want to watch one, have a dedicated time, so we're not like hopping around and jumping around so much. Oh, boy, because that's a lot of juggling to do. That's just me just being selfish, of course. Hi, Cynthia. Hello, hello. How's everyone doing today? How's your morning or afternoon? It's still morning for me, actually. It's going to be afternoon in about like 20 minutes.
All right, this is CR 0124316665, State v. Kohberger. On behalf of the state,
So we got Judge Hippler here. Bryan Kohberger, the defendant, is in the white. Ann Taylor, his defense attorney, and or his other, we have the names here. Bika Barlow, I think, is the new attorney that's been representing him. And then I think this is Elisa Masseuse. I hope I got the names right. The state's down there, and I don't really know the name of the states. Actually, do I? I know Ashley Jennings, but I don't see her down there. There's a new attorney that was added named Joshua Hurwitz for the state. And then I'm assuming maybe this guy right here with the beard, maybe that's William Thompson. I'm just guessing here. If I'm completely wrong, just correct me, please. I'm great after 2 weeks of vertigo. What? Vertigo? Damn, that sounds horrible. Why were you getting vertigo? Now I'm making cookies with my granddaughter. Oh, that sounds fun. What kind of cookies are y'all making? Hi, lady. How are you doing today? Hello, hello. I've been obsessed with dark chocolate chip cookies with like a little bit of sea salt. Oh my God, so fucking good. I've been hopping around to all the different bakeries in the area and just like getting their cookies and seeing which one is the best. And I got to chill the fuck out because cookies, sweets, all that stuff, it like fucks with my skin and I just get pimples like bloop.
have Mr. Thompson and Mr. Horowitz.
Oh, that is Mr. Thompson. Okay, Mr. Thompson is there. Mr. Herbert is there, but I don't see Ashley Jennings.
And on behalf of, when should note the defendant is present with counsel, Ms. Taylor, Ms. Massoth, and Ms. Barlow. This is the time set for, or at least the public portion of today's hearing is set for the motion to continue the trial filed by the defense. So we'll start with that.
You made parakeet-shaped sugar cookies for my girlfriend for the anniversary of her adopting her parakeets 2 months ago. Oh my God, that's so cute. If you have pictures, post them in the Discord. I want to see the cookies. Chocolate chip and chocolate chip and sugar drop cookies. Oh my God, that sounds so good. I have such a sweet tooth right now. Like, you guys have no idea. I'm trying to chill out because right now I went to the grocery store last weekend and I got a half pie of blueberry pie, which sucks, by the way. And then I got 2 chocolate chip cookies, one that's like very thick, luscious, delicious. And then the other one's like a very thin one. It's like super crispy. And then I got a box of brownies. I'm like, what am I doing with my life? I need to chill the fuck out.
Good afternoon, Your Honor. Your Honor, our motion to
Good morning, Ann Taylor. Again, she's Ann Taylor for the defense. And here she goes.
continue has been filed and is necessary to protect Bryan Kohberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically, a continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Kohberger's right to present a full defense, and if it should come to it, a fair sentencing hearing and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have talked about the discovery.
Now, the state in their argument, I read it about a day or two ago. They were saying that, well, defense, they've been following up with all the deadlines in a very timely manner. Do they really need an extension of time? It seems like things are done in a very, it seems like they're being pretty diligent with following timelines. So what's the deal here? And then they were making accusations saying the defense is trying to explore every history possible about Bryan Kohberger, and that's like unnecessary for this case. They already have all the background stuff they did for Bryan Kohberger. I remember they hired I forgot who the experts were. There was like, I think a neuropsychologist, maybe a psychologist, and then some other behavioral people that did assessments of Bryan Kohberger. They talked to Bryan Kohberger's family members. They talked to his teachers, I think, students that were either in his class, his coworkers and stuff like that, to try to get like an overall background on Bryan Kohberger.
Issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I also
want to point this out that I do remember in the last hearing, I think the judge, it was either in the last hearing or it was either in the court docs, but I remember the judge saying, hey, like, if you need more help, hire more people. Why haven't you hired more people yet? So I know that they recently hired Bika Barlow a couple months back, but I don't know if you need help with the discovery stuff. I don't know, maybe, I don't know, get more people in the office to help and go through all the discovery stuff. Because, 68 terabytes is a lot of fucking information. But the state said that, like, well, we point out the information that was pertinent to you. And I'm assuming the defense probably wants to go through, like, everything just to make sure they don't miss anything. Hey, just join the Discord. Welcome, welcome. Yeah, if you're in the Discord, post your cookies on there. Any pictures, pets. I love them all. Yesterday we made brownies and Lady Lunch. Wait, what? Lady Lunch peanut butter bars? I've never heard of that. What is it? Lady Lunch Lady peanut butter bars. Had a brownie last with vanilla ice cream. Oh my God, that sounds so good. Ugh, ice cream, yum. Also been seeing a hell of a bunch of teenagers lantern bugs. Oh, in the yard and garden area, trying to see what will take them out before they do more damage. Teenage lantern bugs. Oh, I guess I was thinking of fireflies. I have no idea what teenage lantern bugs are.
direct the court to look back of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023 and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there and then organized. This case has also faced unique issues, starting with the media coverage of this high-profile case, non-dissemination orders that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment.
Now, In regards to the non-dissemination order, remember how they were trying to do an investigation to see where the leak was? I wonder if they're getting close to finding out who leaked all the information into the documentary.
We faced issues with discovery, particularly with the IgG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately, what we could get was ultimately presented in a motion to suppress, and that's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom, we discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike the death penalty, our motions to compel expert disclosures filed in September and December of 2024, and requests for more time to file our motions in limine that was granted in January of 2025. Throughout the course of the motions in limine and then a motion to strike death based on discovery issues in February and March of this year, the record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast and we have not had a chance to review it all. That we met deadlines for experts shows our dedication to comply with court orders. It does not depict effective counsel ready to go to trial on this case.
Right, because the state was trying to use it against them, saying they're like, well, they've been following their deadlines up until now, so are they really having issues?
We would submit that it's the court's responsibility to assess this motion to continue with heightened due process.
Oh, I want to read this portion right here. I actually wanted to read this before I listened to the hearing, but I forgot. My bad. So we're just going to weave this in. This is what the state said in their response. The defendant was having trouble meeting deadlines, finding experts are pursuing red flags. He should have sought a discovery extension or trial continuation long before now. I don't know if they did before. I'm guessing maybe not. He did not do so. Instead, defendant retained over a dozen guilt phase experts, 6 penalty phase experts, a mitigation specialist, and has identified over 2,100 pages of purported mitigation materials. Leading up to the pre-trial conference, he exchanged witness lists and exhibit lists with the state without stating that he would be moving for a continuance. All right, back to Ms. Taylor. And
that's required in death penalty cases. The death penalty case is different. That comes from Ford versus Wainwright at 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. The Idaho Supreme Court said the qualitative difference between death and other penalties calls for a greater degree of reliability when death is imposed, and that comes from State versus Creech, 105 Idaho, 362 at 383. Looking at all of the constitutional rights Mr. Kohberger has, effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. And effective assistance of counsel applies both to the merits phase and the penalty phase of a death penalty case. The courts are guided and counsel's guided by the American.
Also, I do want to point this out. Sorry, this is like just random, but if I was making an argument and I was up there, you know, really nervous, I would hate to be making an argument with someone that's staring back at me looking like this. I feel like Judge Hippler always has his face where it's just like, okay, are you done yet? Like, I don't know, man. Like, that would make me so nervous. I would never make eye contact with him.
American Bar Association guide merits phase and the penalty phase of a death penalty case. The courts are guided and counsel's guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith, 539 U.S. 510 at 524 said the ABA guidelines are guides to determine what is reasonable, and that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F3D 1092 at 1109 relies on the ABA guidelines as the proper measure to test an attorney's investigation. In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense.
So in the state's response, in their exhibit that they attached to their response, they did go over the ABA guidelines. Well, they initially did say in their motion saying that, well, you know, the ABA guidelines are just a guide. It's not something that you had to like strictly adhere to. That was my understanding of it. I was browsing around yesterday. Where was that part? ABA guidelines. As to law, the Idaho Supreme Court has declined the invitation to adopt these guidelines. For its part, the United States Supreme Court has ruled that ABA guidelines are just that, only guidelines. That's what the state wrote. But the state was like, okay, well, if you really want to look at the guidelines, they did attach this chart here. And so I guess here are the ABA guidelines. We have medical history, which in the state's response, contain a defendant's exhibit addressed in multiple expert reports. Mental health professionals, family members can testify about this topic. Any missing medical records have been available to the defendant and can be obtained prior to penalty phase. Here's another section. Complete prenatal, pediatric, and adult health information. Again, they're going to list some stuff here like exhibits. Again, expert reports, mental health professionals. There was something that was kind of interesting that I was looking at here. Exposure to harmful substance in utero and environment. No evidence this is relevant. Substance abuse history. Now, I heard this was like reported when I think initially Bryan Kohberger was caught. People were saying that like he used to be a like heroin addict or something like that. And then he turned his life around and then he tried to be really healthy, vegan. And then he moved and like went to school or something. But I don't know if, I just remember hearing in the news. I don't know if that's like substantiated or not. Mental health history containing defendant's exhibit. History of maltreatment, neglect, trauma history, which this is something new to me, which I've never heard before. Records related to a childhood car accident contained in defendant's exhibit and elsewhere in defendant's discovery. So I wonder if there was like a very traumatic car accident that he was in maybe when he was a kid. But yeah, that was interesting. So these are the different categories that they're referencing to. And then the state was saying, well, actually, they did explore trauma history, education history, employment, training history, military history experience, which he doesn't have any, it seems, and other stuff. All right, back to Ms. Taylor.
These apply to the full investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state. That means that we have to review all discovery to be able to present a full defense for Mr. Kohberger.
Hi, Lauren. How are you doing today? Hello. Happy Thursday. Are you guys ready for the weekend? Any plans for the weekend this week?
We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet. Considering what's required at a penalty phase in a capital case, we're required to perform in a way that the jury can carry out their function of individualized sentencing. That means that Mr. Kohberger's background has to be known and investigated and ready to present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors. That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence that may weigh against the death penalty, and that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information. We do have several experts that would be ready for the mitigation portion of the case should the case reach that phase, and they rely on understanding family history and Mr. Kohberger's own history. They can only understand what they've been presented, and the investigation to fully evaluate needs to be thorough. That means that records have to be collected. That means that interviews, collateral interviews have to be done, and those have not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated. Red flags aren't fanciful ideas of what else could we do in this case. They're real things that come up in the course of the investigation.
Oh, sorry, I'm blocking her face. I will put the captions up here instead. Nothing much planned, homework, and daughter's, oh, gymnastics. She's 9 years old. Oh, sounds fun. I've always wanted to do gymnastics when I was a kid. But my idea with gymnastics was like, you like jump into the foam pit and then you like learn how to do like a flip or something. But I had a friend that would do all the really cool classes like gymnastics, dance lessons, and all that stuff. And then once in a while, she could bring a +1. It was always so fun to do that. I second that assessment. You can imagine defending someone like Bryan Kohberger. The evidence against him is overwhelming. Personally, it is my opinion that he is a psychopath that killed those people. Hello, Ditto. Yes. Well, I don't know if you can move it on your iPad, but yeah, you can for sure move it when you're on the computer. So again, Ann Taylor, his defense attorney, is saying that, well, we're not done with the mitigation phase yet, and we need to have mitigation be completely done because the jury, when they're making the determination, especially for a death penalty case, they need to have all the background information about Bryan Kohberger. Now, when I was reading the state's response, the state did say that they disagree because defendant has been able to retain a large retinue of experts, including 6 experts focused on mitigation for the penalty phase. 5 of these experts are mental health professionals. Both a psychologist and a forensic psychiatrist have examined defendant on multiple occasions, reviewed his social and medical history, and diagnosed him with autism, OCD, and ADHD. Collectively, these experts took a deep dive into the defendant's entire life, including by interviewing his family, teachers, coworkers, and even a psychologist who evaluated the defendant as a child. The extensive investigations by these experts contradict defendant's claim that he needs more time to complete a social history investigation. All right, back to Ms. Taylor.
And whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important.
This case is scary. I have a daughter going to college next year. Yeah. Did you watch the doc that came out about this case? The one that had all of the fucking information that was sealed? One of the moms that were, one of them, I think, she was like the mom of the girl who was like best friends with one of the girls in the house, and she was supposed to actually spend a night there, but then the mom was like, oh hey, no, like I need you to come home and watch the dogs or something. So her daughter was actually going to be there, and her daughter could have been, you know, like a victim. But yeah, that's really fucking scary. You know, you spend 18 years of your life raising your fucking child, and then they go off in the world, you know, they're about to, you know, go to college, or they are in college and they're finally living their life, and then it just gets ended shortly because of someone else. Like, it's really sad. I can't imagine that. That is definitely a parent's worst fucking nightmare. You know, you want your children to grow up, thrive, and to live and do what they want to do when they're older.
The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify, but they can't be presented until there's a full investigation. They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances. And that's important for the individualized sentencing that's required by the Constitution.
I'm going to just speed up just a tiny bit. I'm just used to them speaking a little bit faster.
Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Kohberger and his parents. And it's also imperative that his history be complete with educational records, medical records, and those things are still being done to this day. The other reason that a continuance is appropriate in this case is based on the media coverage, the Dateline issue that has been talked about in this courtroom before, and what's yet.
So the Dateline episode that has all the leaks, was it just one episode, right, I think? Does anyone know there's like a part 2 coming out or something? Oh, man. Oh, boy.
To come. The Dateline episode wasn't just a one-time deal back in May. That continues to be talked about. Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Kohberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333. And a continuance may be the way that the court can best protect Mr. Kohberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, That's not all. There's a book set to be released just a few weeks from now to be followed.
Oh, I heard about this book. I think kind of controversial though, the author. Hold on a second. Okay, so we're talking about the Dateline episode. Now, what was her... If Bryan Kohberger gets a continuance because of the, Dateline episode, how does that really help him though? Is she trying to say that like, oh, the Dateline episode is like, there's a lot of eyes on this case right now. She's waiting for the heat to die down. Or I mean, especially for the book too, right? I guess, is that what she's arguing? Just waiting for the heat to die down in order to get a jury selection?
By a docuseries on Amazon Prime. The Dateline episode, that's not all. There's a book set to be released just a few weeks from now to be followed by a docuseries on Amazon Prime. There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in the docuseries, at least, and maybe noted in the book. That is, in and of itself, an exceptional reason for us to have a continuance to let those things play out for a while. I would also note, Your Honor, that jury selection is going to be...
Sun noise.
Jury selection is going to be particularly challenged and will need a great deal of time based on what's happened in the media and continues to happen. Your Honor, our request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Kohberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
All right. So Ms. Taylor wants a continuance because they want to continue during their mitigation phase investigation. She says that they're still collecting information, still collecting records, interviews from other family members, educational records, medical records. So they want to have a, I guess, like a fulsome, view of Bryan Kohberger and his history when the jury evaluates him. And then also she says that because of the Dateline episode and the books that are about to be released soon in a docuseries on Amazon Prime, that this will be on everyone's feed. So I think she just wants time for it to just all die down before they continue with trial. Now, I'm sure the state's going to make this argument, but I'm just going to jump into this anyways. But the state was saying that if an individual has been so impacted by the Dateline episode or any other publicity that they cannot be impartial, they will not be seated as a juror. This case is not the Ada County's judiciary's first experience with a highly publicized trial in the recent years. Like in the courtroom of Lori Vallow Daybell trial, Vallow/Daybell trial, I think Lori Vallow and Chad Daybell, this court is well equipped to select a jury, to handle ongoing media coverage, and to conduct a fair trial in the Ada County Courthouse. The Idaho Supreme Court has rejected defendant's theory that, oh my God, my dog is snoring so loud. It's so fucking cute. It's so cute. You guys can't hear it though because my microphone has like the thing, but oh my God, he's so adorable. Anyways, Idaho Supreme Court has rejected defendant's theory that a continuance is necessary to allow media coverage to dissipate. Oh my God, he's snoring so loud. He's so cute. The court correctly noted at a pretrial conference, delaying this trial would only allow more opportunities for pretrial publicity. True, because we don't know how many other fucking docuseries, books are going to be coming out about this. Are we just going to keep delaying until like people stop making, content on this? There is no reason to think that media coverage will, in this case, will dissipate. All right, let's go back. Let the state make their argument. I forgot that Lori Vallow and Chad Daybell were also tried here. All right. Ann Taylor wants delays for everything. Hope she doesn't get it. Why do you need a continuance? Bryan's lawyers. I can't lie. Lol, Aaron, I second that. Zip it, Ann. I do like Ann, though. I do like her. She's been fine so far. But I do think that she... I feel for her sometimes, though, when the back and forth happens between her and the judge. Because the judge is... I would say he's a pretty hard ass. It's a bit scary. Oh, hey, Katie Cat, how are you doing today? Hello. I love how your name is Katie Cat, but I think you have a dog on your profile picture, right? You have a dog over there? Hey, Corgi, so happy to catch another live. Hopefully I didn't miss too much. No, not really. Well, I mean, Ann Taylor made her argument. She wants to have a motion for a continue to be granted because she's saying that she needs to do more investigation, more discovery stuff, more records and other shit that she needs to uncover about Bryan Kohberger and his background, his past, because it's important for the jury to know about this. And that she talked about the publicity in this case, the docuseries that came out recently, and how there's a book that's coming out soon about this, and some docuseries on like Amazon Prime or something. She just wants the heat to die down before the trial happens. Now we're going to listen to the state. But like I said, dude, if I'm up there making an argument and I'm looking at the judge that looks like this, I'm never giving him any eye contact, okay? He looks like he's bored. He's not into your argument. He's like, dude, let me get the fuck out of here. That's just a vibe that I get from him. I do like him, though, but that's the vibe that I get from him.
Yeah, Your Honor. Of course.
Okay, so this is the new attorney, I think, that's been assigned to this case. Because I've been seeing his name lately in some of the motions. Joshua Hurwitz. I think this is our first time listening or hearing from him. You don't like Anne? She irks you. Yes, that's my Penny girl. Oh, I have 2 cats too. Oh, Penny's such a cute name. My best friend's dog's name is also Penny.
Thank you, Your Honor. I will, I think, address Ms. Taylor's argument sort of in the reverse order in which she raised the issues that she raised.
That's my favorite way to handle things. You know, when you're doing your cross-examination, I like it when they work in reverse. Let's say direct examination just happened and then boom, they end with like a banger, right? Instead of starting over from the very beginning of their direct examination when you're doing your cross-examination, just start with the fucking banger and then work your way backwards. That was my frustration with Adam Lawley, because Adam Lawley was a very, I don't know, what would I call him? Like, he's very, I feel like he had like a system that he followed and he would just follow no matter what, not even looking at context. When there was like direct examinations and then Adam Lawley would do the cross-examination, instead of starting at the end with the banger, he like starts from the very beginning where it's like, oh gosh, come on, you're letting the steam die down.
I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue as opposed to what might happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through.
Yeah, the judge has the same face no matter who it is, state or the defense.
The mitigation phase until the penalty phase.
Sorry.
Has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction. The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo, do I need to hit this button, Your Honor?
And clerk needs to switch it over.
Okay, thank you. So these are cases that we cited in our brief, and I wanted to start my discussion with them. I'll read the top case, which is an Idaho Supreme Court case, evaluating whether counsel was effective in a death penalty case.
Damn, he's got a slide presentation for the judge.
Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence. And then I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch the earth strategy is not required. We're in a standard of reasonableness. And the record that is before the court, and I'll acknowledge we have not seen what specifics, if any, the defense has put forward in its ex parte filing.
It's kind of hard for you, I recognize.
It does, but we have not seen specifics. I did not hear any specifics from counsel just now about these witnesses need to be contacted, these records need to be obtained. And then the court, I think, mentioned at prior hearing we had when this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything specific that we can respond to about that. So I'm at a bit of a disadvantage.
So in regards to the ex parte part that he's talking about, so the defense, they filed something with the court, and then ex parte is just like, I don't know, like, it's like, I guess you file something and then the other side doesn't need to know about it. There's a better way to word that, but it's on my head right now. Defendant filed an ex parte, an additional document that purports to outline what new evidence he might seek and what strategies or tactics he might use to obtain such evidence. Initially, the court expressed skepticism that defendant's motion was properly filed ex parte and ordered defendant to provide a redacted copy of this filing to the state for it to address in its response. Defendant then objected to that order. The state now understands the court has decided not to require disclosure of the ex parte filing. While the state does not concede that the defendant has valid grounds for his objections, it will not address the objection given the court's decision. The state, however, does request that if the court has identified a basis in the ex parte filing to grant the defendant's motion, that the court allow the state to respond to that particular issue. So the defendant, they filed an ex parte filing that outlines like the evidence or like strategies or tactics that they might use, right? And so they don't want to reveal that to the state. However, the court can know that. Now the state was like, okay, well, give us a redacted copy of it. The defendant, they objected to that, and they're like, okay, well, we understand why you would object to that because that's basically revealing your strategy and the shit that you're going to present in trial. However, when let's see. So since the redacted version wasn't given to the state is saying that like, okay, well, if they are asking for a continuance based on this maybe ex parte filing, then we're going to need to ultimately get that document in order to properly respond to it. But it seems like that's not the reason why. And that's why the state thinks that they don't need to respond to the ex parte filing because the defense hasn't raised that issue when they were asking for a continuance. Instead, the defense is leaning on the motion for a continue because of the mitigation phase and doing the investigation and getting the records and all that stuff, and then also the publicity on this case.
Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor, was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are.
And that's what we went over earlier. The state went through like the ABA standards, and then they made a chart saying that like, oh, okay, well, here are the ABA standards, and here's how the defendant fulfilled each and every single category.
Which is a retrospective tool for, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after a conviction, not some checklist that needs to be religiously adhered to in order to actually get to trial. Even if the court were to rely on them heavily, though, the charts that we put together show that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they have witnesses to talk about those issues and they have discovery on those issues themselves. Now,
of course, the defense are probably going to have a difference in opinions in whether or not those categories were fulfilled on the ABA guidelines.
Defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category and also the discovery in the record. So, Your Honor, again, we think that given the legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, there is no basis for a motion to continue. Now, let me turn to some of the specific arguments, and I can take this down, Your Honor, that Ms. Taylor raised. With respect to the media coverage, we acknowledge, as the court has, that will pose challenges for jury selection. The issue, though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court, using the procedures it has established or maybe even modifying them.
I mean, look at like the fucking Sarah Boone case. The Sarah Boone case, like how long did it take for her to finally go to court trial? Like almost 5 years, and there was still a lot of publicity. But I guess like Sarah Boone kind of brought it upon herself with all the letters that she wrote. No, I feel like even though, okay, the letters definitely made the situation worse for her. But I mean, we saw her on the body cam in the interviews. Like I felt like the moment that trial would have happened, a lot of eyes would have been on that anyways.
As the court wants to, can seat a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media.
Almost 5 years. Sarah Boone is our own worst enemy. She sure is.
Every time there's a breaking story,
Good.
Every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger.
That's what I was saying earlier. It's like, I feel like there's always going to be some new materials about this case. I know this is a pretty high profile case. People are going to try to make movies out of it, you know, more books, more series, more docs, podcasts.
And what the defense is asking for, we call it a perpetual continuance. And we haven't seen a proposal about when this trial could take place. If there's a continuance, what seems to be the strategy here is just to delay. And that leads me to, I think, the other point that Ms. Taylor raised, which was to say that, you know, this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game, after, by the way, the trial date was used to oppose an extension that we filed for with respect to our mental health expert.
Oh my God, your bird babies are so adorable. I love how their cage is like so colorful. Oh my God, they're so cute. Neil and Caroline. Oh my God, I love their names. Here, you guys can see really quick. Oh my God, look how cute they are. So adorable. Oh. Are they loud? Oh my God, they have a little wheel too. Oh my God, this is so adorable. Did they run on the wheel like hamsters do? So cute. I love the names, by the way.
At that point, the defense said we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, we believed but did not have confirmation that the defense had a mitigation specialist until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that
Boone's took so long to trial because her attorneys quit or fired. 7 of them not because of the media. Yes, I brought up Sarah Boone because the defense was making an argument saying that essentially, my understanding, it seems like they kind of want to have the publicity die down a little bit because of the book deals and the docuseries and the recent Dateline episode that came out. So hopefully, you know, by the time they do jury selection, all that could be died down and it won't be like new in, I don't know, people's feeds, I guess, like that. But I was just trying to say that, like, you know, like look at Sarah Boone, right? Her trial took so long, 4 to 5 years, and there's still a lot of publicity around it. It wasn't like dying down. But then we were talking about the letters and then the police body cam and the interview that she did. Because even though, let's say that she didn't write all those scathing letters to the judge, to her fucking attorneys, or even like addressing the media, I think there still would have been a lot of publicity in Sarah Boone's trial because, well, the fucking body cam was really bad. The interview was really bad that she did. So I think people would have been like, oh shit, yeah, that's the lady that had the body cam video that came out 5 years ago. Oh yeah, she's having a trial right now. Like, let's tune in to see what happens. Because she was a wacko.
person that's special to submit it. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do.
I mean, they got like 2 months.
Your Honor, again, I would try to get back.
Good morning. Hello, hello. How are you doing today?
To the record and ask the court to look at the objective record when evaluating this motion. 55 mitigation witnesses, over 130 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendant's forensic psychiatrist and then the licensed psychologist. I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists, conducted significant, fulsome life history investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete. And the experts didn't say, we are unable to reach the conclusions we need to reach for lack of investigation.
True. I do remember seeing, because we didn't get the expert reports, of course, they're like sealed, but the experts did say that they evaluated Bryan Kohberger and they're like, yeah, he has this, he has that. And it wasn't like, oh, well, we don't have a full picture of Bryan Kohberger and I can't make my determination based on that. The judge looks super bored. I know, I was telling you guys earlier, I would hate to make an argument in front of the judge or anyone that's listening, because like this would just trip me up, okay? If you don't look like you're invested in what I'm saying, I'm like, I start doubting myself. Nothing dies down. If anything, people will be exposed more. Because I think if there is something pending, then I don't think it's going to really die down to the point where people aren't going to be invested again once the trial happens, right? Because the trial is pending. Now, if it was like, let's say, for example, like maybe Sarah Boone, right? Sarah Boone, her shit might die down because there's something else pending in her. Unless there's some appeal stuff that happens, then maybe the interest will ramp up again, or she starts writing some like batshit crazy letters. Then maybe people will be like, oh, let's tune in to Sarah Boone. However, because there's nothing pending for Sarah Boone, it'll probably just naturally die down. For Bryan Kohberger, well, what's pending is this fucking trial. So I think a lot of people are still going to be waiting and, you know, waiting to see what's going to happen. Waiting to see what happens in the trial.
So I think that is sort of proof in the pudding. We have life history for the defendant. The defense has amassed significant materials. And I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance.
Any news about the leaks? Dude, that's what I'm wondering. I'm like, have they found the person yet? Are they getting close? What's going on? I mean, it's not like they're going to tell us. I don't think they're going to tell us. I don't think we'll know anything about that. They found enough jury members to vote for both Lori and Chad's trial, and that was also a national news case because of the kids. The trouble I see with this one will be the time the trial will take. The judges give me Boreski vibes, very nonchalant. You mean Lori vibes? Nonchalant enchilada? Don't tell Lori that, though. That triggers the fuck out of her. If you say that she's nonchalant, she gets so triggered.
We have life history for the defendant. The defense has amassed significant materials, and I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance. And to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course, to occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on the case law holding that a scorched the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Wait, hold on a second. There was a trial recently that was a bench trial. Oh, what was it? I wasn't covering it, but I remember watching a true crime video. I think the trial happened recently too, or was it not recent? Shit. But they opted for a bench trial. I mean, they still got fucked, but fucked as in they were still found guilty. What was the case? Oh gosh. Were there any trials recently that was a bench trial? Maybe it was like an old case then, and then they're just talking about the trial coverage. Okay, I don't remember. I've been watching a lot of true crime videos.
Any reply?
Yes, thank you.
Oh, she gets the last word. Yay. Yeah, so again, the state was saying that, well, it seems like they've been following through with all of their discovery not discovery deadlines. They've been following through with all their deadlines, so it seems like they are working in a very timely fashion, and that their belief that there might be ineffective assistance of counsel, it might just be their own subjective belief that they have. And he's saying that's not really supported by the actions of the defense team, because the defense team, they again followed with all the discovery. I keep lumping discovery deadline together, but they're following through with all the deadlines that has been put forth on them. They've hired more people. They've done this investigation. They've gotten to these experts and all that stuff. So the state is basically saying that, yes, this defense might be saying that they want to do like a, very thorough investigation to Bryan Kohberger's life. However, that's not something that's warranted. He talked about the scorch the earth strategy. So it seems like they've already hired experts to talk about Bryan Kohberger's past, and they've done interviews. They've got some records and stuff like that. But I'm guessing Ann Taylor just says that, she just wants more. She just wants more information to give to the jury. And then again, for the media coverage, same thing. They know there's a lot of publicity on this case. But it seems like, despite all the widespread publicity, the state still thinks that they're able to seat a impartial jury, especially since they moved from Latah County, which is a much smaller county, to Ada County, which is where Chad and Lori were tried.
I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records, of Bryan Kohberger.
Wait, what? Whatever happened to the treehouse killing? Oh, I haven't heard about that case. And him getting a hung jury, is he getting a new trial? Depends on the state.
A lot of the witnesses that refuse to speak with us
Go back. Sorry.
I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records of Bryan Kohberger, past treatment records of Bryan Kohberger. Those are important things that the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information. Your Honor, I want to touch on just a couple of points.
Baldwin had been a bench trial. Baldwin was a jury trial, if I remember correctly. Yeah, I think it was a jury trial. Because I think there were times, they addressed the jury in the beginning. And I remember the judge addressing the jury before opening statements. Yeah, I think that was a jury trial. I think the bench trial that I'm thinking of, it must have been a video that I watched about a true crime case, about a trial that happened like years before. Wait, was it the one with, there's this crazy one that I was telling some people in Discord about. It was the one about this woman who had someone break into her house, assault her, and then while she was outside, basically like waiting for the intruders to leave, like they were like, oh, hey, sit outside and then wait until you hear like me honking the horn or something. So she was sitting outside waiting and she was like super fucking traumatized. And then all of a sudden her savior comes. It's her ex-husband. Ex-husband shows up and he's like, oh my God, what happened? Like, are you okay? They call the police and everything, and the police arrives, and then she's like giving the interview, and she's like, I think it was my ex-husband that did this. I think that was the one that went to bench trial. That case was fucking crazy. I linked it in the Discord. I think it's called like the Batman break-in or something. Batman intrusion. Fucking crazy. That ex-husband was batshit crazy. And they had 2 kids together, twins. So he basically wanted to get back into his wife's life by being the savior when he was the one that committed the crime. Fucking crazy.
Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Bryan Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Bryan Kohberger's full life history. These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years.
In federal court.
In federal court.
Which moves at a snail's pace in its best day in regular cases.
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where we have a...
See, like something like that would just lose my, I would just lose my steam arguing. I'd be like, okay, all right. All right, Ann, you got this.
Court. So I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where we have a client and we need to investigate both the merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high-profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel that's required. All of those things take time to do in a case like this. 2.5 years is excessively fast to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Kohberger's team did not delay in getting experts to help us understand specific areas of the case. Looking over the entire record, the court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Kohberger...
I wonder if it would help her in her argument to get into the specifics, maybe? Not revealing shit about Bryan Kohberger's life and stuff like that, but like specifically like what information they need from like XYZ person. Maybe there's like a person they're trying to chase down and they haven't gotten in touch with them. Because it just sounds like very broad. Like her arguments are just very broad. It's like, hey, like we just need more information, you know? Like this is a death penalty case and we just want to make sure that we have everything for the jury.
Has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information and there's this other stuff that's out there, that's a red flag, that's real, that you need to investigate, your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, that's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.
Yeah, they filed the ex parte, but it seems like they're not leaning on that ex parte because that wasn't brought up in their motion for the continuance. And that's why the state was like, okay, well, if they're not going to bring that up in their motion for continuance, instead just focus on the mitigation stuff and the publicity, then we don't need to have a redacted copy of their ex parte filing. Because the ex parte filing has, I think it was like evidence and what was the other one again? What did I say earlier? It was evidence and I can find it. Ex parte. Ex parte. Additional documents reports to outline what new evidence he might seek and what strategies or tactics he might use to obtain such evidence. So the state was saying that, you know, if the ex parte is not part of their, the reason why they want to get a continuance, then the state doesn't need to get a redacted copy of it in order to address it. 56 defense penalty phase witnesses is ridiculous. Hey, Nicole, how are you? How's it going? Spoiler alert, the judge is not going to make his decision today, but based on what he says, it seems like he's going to follow the schedule.
All right, I'll take the matter under advisement and get an opinion out in short order. In the meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again, I reserve the right to write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated. All right, is there any other matters that we need to take up in the public session before we break to go to the private session?
Nothing further in the public session, Your Honor.
No, Your Honor, I don't believe so.
All right, we'll take a 10-minute break while the bailiffs clear the courtroom and we set up for the private session.
All rise, please.
Oh, no private session for us, y'all. So the private session, they were going to talk about the, what's it called? Possible culprits that could have been involved in this case from the defense's presentation. So we're not going to be a part of that, unfortunately. Alternate perpetrators, right? Alternate perpetrators, yeah. Okay, all right, guys. So I do want to hop onto this part really quickly. I haven't seen this yet, but there's been some rumblings about a DoorDash driver that could be the state's witness, saying that they saw Bryan Kohberger at the crime scene, I think. But I don't know how... I don't know how solid this is because I haven't seen this yet. So let's watch it together. We're probably going to jump around. I see like a police body cam interview. So we'll probably jump around a little bit. Let me have the transcript up too. All right. So there's that. We will wait for the judge to make his decision, but it seems like the judge is going to probably continue with the time that they have for the trial, which is going to be August trial for the Idaho 4 murders. All right. Now we got Jesse here. Hi, Meat Popsicle. How are you doing today? I hope the cameras aren't like this in trial. It gives me a headache with the 3 screens. I hope that, you know, I don't want to be picky as long as the audio is good. And, you know, yeah, as long as the audio is good. But it's better than, do you guys remember when we had Chad Daybell's trial that was live streamed? Chad Daybell looked like a fucking thumb. You couldn't even see anything. This DoorDash driver's a hot mess. Yeah, I don't know. All right, let's read what Law and Crime says. A shocking twist in the Bryan Kohberger case. A woman identified as MM in court documents claims that she was a DoorDash driver who delivered food to the victim's home and says she saw Kohberger at the scene the night of the murders. This revelation comes from a DUI body cam video recorded nearly 2 years later, now fueling speculation about a new eyewitness in this case. Is this the prosecution's ace witness? What does it mean for the upcoming trial? Was that dramatic enough for you guys?
On the scene of a gruesome crime.
So this is September 5th, 2024. All right, so like last year.
So yeah, because I'm a DoorDash driver, so yeah. You have to testify in which murder case?
Did we just find out about a major witness planning to testify?
Who found this? Who found this body cam and then tied it together? Interesting.
In Bryan Kohberger's upcoming murder trial? Through body cam footage from an unrelated DUI stop 2 years after the killings of those 4 college students, people online and reporting indicates this woman, a potential delivery driver, may have seen Bryan Kohberger at the crime scene. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber.
Yeah, I wonder who in the public found out about this. Or was this also a part of a mini leak, possibly? All right, well, let's jump around. Hopefully we can just, I don't know. The body cam is so short. I don't think they're going to show the entirety of it, right? All right, here's the body cam footage. Let's see what it says.
After 4 a.m. Now, why is this coming out? Well, it turns out there is a police body cam video that has been posted to the YouTube account Officer Axon. They apparently
did they post this? And then people were like, wait a second. DoorDash driver, hold on a second. Murders? College girl. Oh, the internet probably put the 2 and 2 together. I don't know if Officer Axon uploaded knowing that it might be tied to the Idaho 4 murders. Interesting. Oh, yes. God, Chaz was terrible. I think the video and wasn't the audio really bad as well? If I remember correctly, I think Chaz was really bad. And then Letitia Stout as well was also really bad.
Apparently publish police videos through public records requests. And this is reportedly from September 2024. So you're talking about 2 years later, out in Pullman, Washington. Again, Kohberger was a PhD student studying criminology at Washington State University in Pullman. And this interaction with police centers around an alleged DUI stop. So it's not related to the killings. However, the woman in this video says in an interview room, as she's covered by a blanket, the following.
And
Now I have to testify. Murder case too, so yeah, because I'm a DoorDash driver, so yeah.
you have to testify in which murder case?
Murder case for the college girl.
Oh.
Have y'all seen the body cam footage of this yet? On Officer Axon on YouTube?
I'm a DoorDash driver, I saw Bryan.
I can't hear what she says.
Now, in case you couldn't hear what she says, she apparently says, I have to testify in a big murder case here because I'm the DoorDash driver. So,
okay, I got that.
yeah. And the officer asks, which case? She responds, the murder case with the college girls. I'm the DoorDash driver. I saw Bryan there. I parked right next to him. Wow. I know.
I didn't hear that part, but I guess I didn't have my gain up all the way.
So people online, they were quick to make the purported connection here, right? The question, of course, is this true? Is she credible? If she testifies, what does this mean? What did she see? Hey, everybody, this is a lawn crime legal alert.
Let's see. I think that's about it. Is there a way? Do you guys know when this video was uploaded? Let me see if I can find it. What's it called again? Axon YouTube? Axon. I just want to know what prompted her to say that. Just curious. Officer Axon DoorDash driver. Oop. Oh, there's a lot of these. Hold on. Officer Axon. Shit, I'm spelling it wrong. DoorDash driver, Idaho 4. Do we have the link to the original video? Officer Axon, YouTube. You guys have it? Can you guys link it in the Discord for me? Officer Axon. Did they post this a while back? Oh, there's a lot of videos here. Hold on. You said it was who found it again? Idaho Statesman. All right, Idaho Statesman. I think that's all that we have for this video. All right, let's read this. Read this article. Boop. Boop. Go away. No notifications, please. We're good. All right, let's see what we got here. Oh, why is it all funky like that? Oh, there we go. Zoom in for you guys. Here we go. Moscow woman who said she worked for a DoorDash food delivery service expects to testify at Bryan Kohberger's upcoming murder trial that she brought an order to one of the victims in the University of Idaho student homicides and saw the suspect. 44-year-old woman told police following a traffic stop last year in Pullman, Washington, that she delivered food to the home at 1122 King Road in Moscow moments before the 4 undergrads were stabbed to death early in the morning on November 13, 2022. She also told an officer with the Pullman Police Department that she may be called to stand at the high-profile trial, according to a video in the conversation, the body cam footage posted on YouTube. Oh, yeah, we got a link here. Thank you.
And
Oh, this one right here. Oh, wow, they even put the timestamp. Nice. Thank you so much, Idaho Statesman. You guys are fucking awesome. Again, they're quoting her. Now I have to testify in the big murder case too. I'm the DoorDash driver. I don't know if I heard I saw Bryan. I parked right next to him. Do we hear that? I didn't hear it.
I have to testify. Big murder case too, so yeah, because I'm the DoorDash driver, so yeah.
you have to testify in which murder case?
Murder case for the college girl.
Oh.
I'm a DoorDash driver, I saw Bryan.
Something I saw Bryan. I kind of heard it. Okay. I don't know. Maybe I'm just looking for it. Maybe that's why I heard it, but it's hard to hear. So I do wonder why was that prompted? Let's see. So medication. Oh, okay. So she had PTSD, she had depression. My husband was murdered in front of me, shot times, friends. Where did that happen? In Moscow. She saw her husband murdered in front of her? Jeez. Is that what happened? I guess we'll just listen to it.
My doctor and police, yes, they're all diagnosed.
Okay.
I have PTSD, I have depression, I have insomnia. My husband was murdered in front of me. He was shot 9 times.
Okay, that's the context. Got it. Okay, so she's talking about the PTSD that she has, depression as well. And then that's why she's letting the officer know about also like the other case that she's also going to have to be involved in as well. Because that's probably really traumatizing for her if she saw that. Got it. Okay. I parked right next to him, she added. The Idaho Statesman is not naming the woman who hasn't widely identified herself as a DoorDash driver. Kohberger 30 is charged with killing the 4 U of I, University of Idaho students at the off-campus home. The victims were Madison Mogan, Kaylee Gonzalez, both 21, and then junior, Xana, and then freshman Ethan. Kurt Noodle received a DoorDash order at approximately 4 a.m. November 13, police said in the probable cause affidavit. More recently, prosecutors said the 4 homicides happened within the 13-minute window between 4:07 and 4:20 a.m. Yeah, I mean, we already knew about the DoorDash driver. I think initially people were thinking, oh, maybe the DoorDash driver was involved. Maybe they did it. That was just like speculation before they were able to find Bryan Kohberger. So we all knew about the DoorDash driver, but we didn't know what the DoorDash driver knew. We just assumed that they didn't know anything. But again, a lot of stuff about this case is just being sealed from the public. Oh God, you guys can see my messy room. Ah! I didn't move my the spare bed from my office yet, so it's still here. Okay. Honestly, I think that's just about it. I don't think there's I think they're just gonna discuss it, maybe. I think that's about it. All right, well, I will link this video and I'll link the article, and then if you guys want to watch the body cam, I'll link it for you guys as well if you guys want to watch it later on. That way you guys can get the context of it. Damn, that is rough. Yeah, that's super sad. My understanding, she's been known as a witness for years. Yeah, that's what I'm assuming too. I'm assuming that the state already has her as a witness. However, because it wasn't known to the public, and then this body cam footage came out, and then the article came out about it, now the public knows, oh, actually, the DoorDash driver could be the eyewitness. So, all right, guys. I apologize for the mistake. I like Judge Hitler. Oh, people do be calling him Judge Hitler, though. I wasn't sure if you're doing it on purpose. I see it on Twitter. That dude looks like Dennis from Always Sunny. Oh, I need to watch the TV show. It's really good. I've seen like a couple episodes here and there. I don't remember who Dennis is, though. Yeah, body cam was from, I think it says November 2014. All right, y'all. Well, I just wanted to see what was up with this because I haven't seen it for myself, but I saw it rumbling on YouTube about a DoorDash driver possibly being an eyewitness for the Idaho 4 murders. So, guys, for today, we covered the hearing that happened yesterday. So, again, the defense was arguing for a motion for a continue, basically emphasizing on that they need to complete the investigation they need to complete the mitigation phase. They want to do more interviews. They want to get more records from people. She also mentioned interviews from other family members. And then also she talked about the publicity about this case with the Dateline episode. And apparently there is a book that's coming out about this case coming out soon. And then also some docuseries on Amazon. So my sense is that Ann Taylor is basically saying that, like, let's wait until the heat dies down before we do jury selection. Now, the state was saying that, well, we had Chad and Lori. They had their high profile case here. We were able to find a partial jury, and that the defense, they've been following all the deadlines so far. It seems like they're doing things okay, and that they're necessarily, because they think that there might be an ineffective counsel, it just maybe just like a them thing. It seems like from what we've seen from the record, it seems like they're doing okay on this case so far. So the judge said that he was going to reserve his ruling. I think he was going to consult with someone or something like that. And then he was basically telling the defense that, hey, just act like the trial is going to happen in August. And then I'll let you guys know what my decision is. So we'll see what the judge decides. We'll see if they decide to push the trial out a little bit, or if it's going to clash with Donna Adelson. But who knows? Maybe Donna Adelson will have her trial moved as well. So I'll keep an eye out about that. And then we covered the DoorDash driver, who seems to possibly have been the state's witness from the very beginning. But again, it wasn't something that was disclosed to the public, because a lot of things about this case is sealed, and we have to wait for the trial for more information about it, which makes sense. All right, guys. Well, that's about it for today. That's all I got. That's all I got for you guys. If anything else pops up about this, I will let you guys know. I keep going on the website, keep refreshing to see if there's any new documents that have been uploaded. And I'm trying to think, is there any other hearings that are coming up soon? Lori Vallow is going to have her sentencing next month for the Arizona murder, and then the attempted murder of Brandon Boudreaux. Let's see, what do we got here? Donna Adelson, we covered her earlier this week. Oh, we did a video on Donna Adelson. If you guys want to catch up with Donna Adelson, check out the video that we posted. Or if you guys want to watch the longer version, there's a live stream version as well. So I have the live stream version for those who want to watch like the entirety of it. And then I have like videos that I usually edit down if you guys want to listen to the entire thing. What do we got here? June 18. Yeah, all I have next is sentencing for Lori Vallow and then Bryan Kohberger's trial. Isn't Stephen Stearns supposed to have his trial coming up next month or something like that? Fuck that guy. Prosecution, defense, or adversarial. I don't think either side respects one another. It's been ongoing. I feel like what do I think about the state of defense? I feel like the judge has really reeled both sides in. So we don't really get the theatrics, the dramatics in the courtroom. But there are some cases where, did you ever watch the one with the, one of the worst judges, in my opinion, was the judge in the shooter, what's it called? The Crumbly case. Remember the Crumbly parents? They were charged, essentially, what the fuck were they charged with? But their son, committed a mass school shooting, and the parents were tried. Now, in the courtroom, the judge just could not hang on. Like, I don't know. She just didn't have a rein on the attorneys. The attorneys were like, dude, they were like scathing. It was like the state versus the defense, and it was fucking wild, dude. I felt like we were watching like the Jerry Springer show or something. It was so dramatic. That case was wild. That one is like, damn, they definitely fucking hate each other. Pre-trials for Stearns, July 3rd, you think? Okay. July 2025 for... Oh, the murder trial's in September. Okay. I wasn't sure if they were planning on lumping that together. I knew they had it separately, but I wasn't sure at some point when they realized that Maddie was deceased, and as they had more information about that, I wasn't sure if they were going to lump it together. Wow. That's a really sad one. That's a really sad one. That one really upsets me. Especially, like what Stephen Stearns, it was like really fucking disgusting, but like, I don't know, like the mom really upsets me as well. I don't know. That one really pisses me off. All right, guys. Well, that is it for today. You know, I hope you guys have a happy weekend, and hopefully I get some yard work done because, you know, my garden is like, they are hungry right now. They need some food, but it's just been really hot to do yard work here, and I haven't had time to wake up early enough to do the yard work. So my garden is hating me right now. But we'll see what else pops up for all the other cases that we've been covering. We'll continue checking all of the court websites and all that stuff. And then, oh, also, I think I have access to the Sarah Boone family stuff because they went to trial. So I haven't really looked into that yet, but I might pop in and just see what's up. But yeah, Sarah Boone versus Boone. I think Sarah Boone is still fighting for alimony and child support, if that's my understanding, if it's correct. I'm like, girl, you need alimony and child support, especially if you're fucking incarcerated right now. Jesus. I don't know. I think I have access to all that stuff now. So we'll double check and see. I don't know why they keep wanting me to confirm my email. I already confirmed my email. I already submitted this. Oh my god. Okay. Gotta deal with the Orange County stuff. All right, guys. I hope you guys have a good one. Take care. And I appreciate y'all being here. I even have time to do my face because I just wanted to do this stream before I do the rest of my shit for the rest of the day. But I appreciate you guys being here. I hope you guys have a good one. Join the Discord, you know, post your cookies, you know, post pictures of your pets. Feel free to join the Discord. We do have a true crime section. And yeah, other than that, you guys have a good weekend if I don't see you until then. And you guys take care. I'll see you guys later.